pleasure to welcome everyone to today's session, and even more importantly, to welcome our speaker today. Our speaker is a partner with Banwo and Igodalo. It's a legal firm. So join me as I welcome Mr. Olumide Oshundolire. Good afternoon, sir.
Good afternoon, Akinwumi.
Good afternoon, sir.
Good afternoon, everybody. I hope that we've had a good day and that we continue to protect ourselves and keep ourselves safe from at least comply with all the measures that federal government has and Lagos State government has recommended to prevent the spread of COVID and to also protect ourselves from the scourge of COVID and also stay healthy. I'm going to be speaking about navigating the legal implication and risk for your business. And I will try to keep this straight and short, hoping that I will have time, at least create enough time to deal with Q&A, and hope that in Q&A we can then dig deep to address issues that you may have experienced or be facing or have heard about. I must give a caveat at this point that whatever I say here is for education and discussion purposes only. It does not take the place of a legal advice, and I will advise you that you seek legal advice, you consult a legal practitioner, give him the necessary information regarding the situation you may be in, so that you can then have a detailed, well-researched advice on whatever issue that you are going through. So moving on. I intend to, under this topic, we'll have a brief discussion about the introduction, just doing context setting. Then I will launch into the 4 major issues that usually come up, which you need to take into consideration and address: contract performance issues, labor issues, data protection issues, and governance issues. So let's quickly speak about our context. The context in which we're having this discussion is with respect to the outbreak of COVID-19 and the impact on business and commercial transactions globally. As at yesterday, or as at 3rd of May 2020, the data or the statistics show that over 3.5 million people have been infected in over 212 countries and territories, and that we have about 240 something fatalities. I'm sure it will have increased significantly by now. And what you then find that has happened is that in an attempt to curb the spread of the disease, the government in various countries have imposed various degrees of restriction, from outright restriction, very strictly enforced, as in places like India, to places like Sweden, where citizens are expected to behave responsibly and to take necessary precautions. So there have been various degrees of restriction, and that has impact on business. In Nigeria, we all know our story. 4 weeks back, the federal government imposed restriction in Lagos Abuja, and then Ogun State. That was extended by another 2 weeks or 14 days. And today is the first day of the gradual restriction or lift of the lockdown imposed by the government. In some other states that are not covered by federal government restriction, have gone ahead to impose varying degrees of restriction. Port Harcourt, you're supposed, in River State, you're not allowed to go out without face mask. Kaduna are under lockdown. Interstate movement has been restricted, save for in respect of essential goods and services. And so the impact of this is that non-essential business have had to stop operation. And so if you are not in the category of the economy that is called essential business, telecommunications, medical, broadcasting, security, then you are in banking and finance, you are likely not to have operated your business for a while, and you are still at this point considering the impact going forward of COVID-19 and what to do. So let's discuss issues as they come up now. The biggest issue that comes to mind when you are looking at the legal implication of COVID-19 pandemic will be contractual issues. And this is obvious, since commercial transactions are built on contract and built on contract, and there has been restriction of movement, of activities and all those things. The implication is that there would have been either non-performance or delayed performance of obligations under these various contracts. I repeat again, due to the lockdown, due to the resultant failure to operate, to run the business, most businesses will have suffered one way or the other from non-performance of contractual obligations or delayed performance. So for instance, if you are into logistics, and unless you are hauling food and other essential goods and services, your truck will not be permitted to move, and therefore you will not be able to perform any carriage contracts that you might have executed with any business, assuming that that business in itself is even operating. Now, if someone had hired you to carry consignment of goods to a third party, that would then mean that you, because of the lockdown, cannot carry the consignment. The third party who had been engaged to carry the consignment, who has been engaged by that third party to carry the consignment, which has been subcontracted to you, will not be able to perform the contract because you that he engaged to perform the contract hasn't been able to perform the contract. And so the third party is faced with non-performance by you. You are faced with non-performance by the carrier who is supposed to carry the consignment. Now, under law of contract, failure of performance or delayed performance, where time is of the essence, constitutes a breach of contract for which the innocent party may be entitled to damages or rescind the contract. Depending on the obligation, the severity of the obligation, there's something we say. If the obligation goes to the root of the contract, then failure to perform may be treated as not only breach of contract, but also be treated as a rescission of the contract, so that he can walk away and go and get somebody else to perform the contract. In some instances, all the innocent party will be entitled to will be breach of contract, while the breaching party has the obligation to still perform the contract. What you then find in some places too is that in certain instances, the contract will expressly say that if you fail to perform the contract by X day, the company or the client is free to then terminate your contract and engage a third party, and then you will be liable for any additional cost that the client incurs for engaging a third party to perform the obligation that you have failed to perform. So there are different ways in which this the contract will usually play out, or will state the remedy to which the non-breaching party will be entitled. But the bottom line remains that if non-performance or delayed performance may be treated as breach, for which the non-breaching party will be entitled to some form of remedy. However, what you can't be glad about is that failure of performance or delayed performance may be excused under certain circumstances, particularly where relevant provisions have been inserted in the contract. Now, there are different types of provisions. There's something that we call force majeure clause. We will discuss that. We also discuss frustration of contract. And we also, but I did not say the extension of performance period is pretty straightforward. We usually find in contracts, particularly construction contracts, where parties will be given a particular period of time to perform their obligation, say 18 months, 2 weeks, 3 weeks. And then there will be provision that says that where the contractor reasonably believes that there may be construction period or performance period overshoot, that person should immediately contact the client, provide necessary detail to enable the client or the employer take the necessary decisions, and an extension of the period within which the contract and the obligation will be performed will be given, and usually it will be capped. And what you then find is that when the person fails to perform within that period, there's some form of penalty may come in, usually called liquidated damage. So let's quickly discuss force majeure. Now, force majeure is a French word. It describes a supervening or foreseen event which is beyond the reasonable control of the affected party. The expression has no legal meaning in English law. As a matter of fact, until 19th century, the expression or the principle was alien to English law or to common law. Nigeria is a common law. UK is a common law. Most of the countries that were colonialized by UK practice common law. Quite unlike the continental Europe, they practice civil law. Civil law has its roots in old Roman law. Now, under the common law, there is no principle like force majeure. It was adopted, it was borrowed from the civil law countries. And as a result, if you're in a common law country and you need to invoke the principle of force majeure, you need to expressly capture it in your agreement. And if you don't do that, then it will not be implied. Now, the effect of a force majeure clause is that the moment it is triggered, it suspends the performance of that affected party's obligation while the force majeure continues. So the intention is for the contract, for you to resurrect the contract. So the contract goes into an abeyance during the period of force majeure, with the rider that the moment the force majeure ends, the contract will resurrect, the obligation that has been suspended will resurrect and must be performed in accordance with the provisions of the agreement. Now, what you need to also understand is that in certain instances, or in some contracts, will place a time limit on that suspension of obligation. And if at the expiration of that period, nothing has happened, then parties may terminate the contract, or the other party that's not affected may have the right to source for the performance of that obligation somewhere. So, but in essence, what you need to know about force majeure is that if the provision is included in your contract, it excuses you from non-performance for as long as the force majeure event continues, but it also imposes on you an obligation to mitigate the effects of that force majeure in a commercially reasonable and responsible manner. So you are not expected to mitigate it by going to incur unnecessary costs, but you should, as a prudent businessman, take steps to mitigate the effect of the force majeure and be ready to resume your performance upon the expiration of the period. Now, like I said before, force majeure is alien to common law countries. It has no statutory definition, and as a result, what constitutes force majeure is often open to interpretation. Parties in negotiating their contracts will agree what they believe should fall under that term force majeure. What you will usually see is that it will say force majeure events such as acts of God, flood, declaration of war, embargo, and so on, etc. Now, the way the courts will interpret such provision is to say that we have a term, a principle in law called a jusem generis, meaning that a word of general interpretation that is inserted, that follows a list of limited, restricted words with limited interpretation, will take its construction from those words with limited interpretation. So, for instance, if you say table, chair, stool, etc., etc will then be interpreted to include all furnitures that fall, or all goods that fall within the same line as table, chair, and stools. So the same thing will happen if you say force majeure and you limit your force majeure to possibly acts of natural disaster. Then what will happen is your and so on and so forth, or your etc will only take meaning within the context of natural disasters and nothing else. And so it will be necessary that businessmen will need to go back to their contract to consider how the force majeure clause has been constructed, to be able to interpret it, to see whether situations like this will fall within the interpretation of force majeure clauses. This position or this situation brings to mind two issues. Number one is that before now, force majeure is treated as a boilerplate clause. A boilerplate clause is a clause that is inserted for the administration of the agreement itself. it does not necessarily apportion risk between between parties to the agreement. Rather, it enables the parties to administer the contract between themselves. And as a result of that treatment as boilerplate clause, what you find is that most people don't pay much attention to what they put in a force majeure clause. But with the current development, it's definitely going to become one of the most important provisions in the contract. Now, what happens to you if, one, you don't have a force majeure provision in your contract, or two, the force majeure provision does not actually cover the current situation? One, you can go back and renegotiate. And if that does not work, then two, you may want to then consider our next issue, which is frustration of contract. Now, frustration of contract describes a situation where an event has occurred after the execution of contracts, which could not have been foreseen or envisaged by parties at the time they were executing the contract, and which was not caused or worsened by the party trying to rely on it, and which has a fundamental effect on the contract, such that the continued performance becomes impossible, unlawful, or completely different from what parties intended at the outset. So this frustration is similar to force majeure in that at the time that parties were signing their contract, none of them envisaged that this could happen. Now, this is one of the things you need to understand about contract. A contract is what we call a risk allocation device. I want to go into a contract. I want to engage someone to provide a service to me. I enter into a contract for us to share risk among ourselves. What risks will come up? What risk do I face in doing this transaction? I will list them. And then in the agreement, we will agree what should happen if those risks should crystallize. That is what that's one of the purposes that an agreement serves, other than being a record of obligations that parties have imposed or agreed to carry. So you then understand how this works. Because it's a risk allocation device, it is expected that when you are executing a contract, you will have thought of what will happen and what is likely to happen, and then you will have made provisions in your agreement to cover all those things. One of the reasons why we keep on telling people, when you want to enter into any business, any transaction, get an agreement. It's very important. Imagine what will happen in this current situation where you have a contractual obligation and it's not recorded in writing. Anybody can do anything. The provisions are left to conjecture, and then it becomes messy. So coming back to frustration, like I said, it's supposed to allocate risk. It's supposed to, and because parties did not envisage that what will happen will happen, or what has happened will happen, then frustration of force majeure may come in. So remember that I said that frustration will apply. Number one, where force majeure does not apply. The two of them cannot apply at the same time. Usually force majeure will take precedence over frustration. Frustration is a provision of law that applies under common law where frustration of where force majeure cannot be sufficiently evoked or effectively evoked. Frustration occurs where an event has occurred post execution of contracts, which parties did not foresee or envisage would happen at that time, which wasn't caused or worsened by the party relying on it, and has a fundamental effect on the contract, such that the continued performance becomes impossible. Now, what happens is that a frustrated contract completely releases parties from their contractual obligation. Note, and see that it's different from force majeure. In force majeure, what happens is that the contract is suspended, or that obligation is suspended until the force majeure event ends. Then the obligation resurrects. In frustration, what happens is that the contract is terminated by operation of law and parties are released from their contractual obligation. So frustration as a remedy may not be available if there is an alternative way to perform the contract, or because the contract has become more difficult or expensive to perform, or there has been a change in economic condition. Frustration will not be available to you in any of these circumstances. Let me explain again. Frustration as a remedy will not be available to you if, one, there's an alternative way for you to perform the contract. You're supposed to carry good from here to Ekpe. The roads are blocked, but you can ferry it down there. Frustration, you cannot invoke frustration in that circumstances. If it has become more expensive or difficult to perform, the issue is it can still be performed. And to the extent that it can still be performed, you cannot argue that the contract has been frustrated. Same thing too for economic condition. A good example will be where one of the celebrated cases was where there was supposed to be, okay, so for instance, you rented a hall for a wedding, and then due to COVID-19, we rented a hall for a wedding, and due to COVID-19, either the bride or the groom passed away, and then the wedding could not be held. Now, that is different from a situation where, due to COVID-19, the wedding was postponed. For one, the wedding could still happen. For the second, the wedding cannot happen again. So one, the contract has been frustrated by a subsequent event, which is outside the control of everybody, and which has a fundamental effect on the continued performance of the contract, to make it impossible, because the hall was meant to host the wedding. Now, as you can see, as you may already have inferred, the termination of frustration of the contract will be dependent on the fact and circumstances of the case, and it is often a decision of the court. Because, as you know, under these circumstances, parties will not be able to agree on what to do. One party will rely on frustration to say that, look, I cannot perform this contract anymore. The other party will insist, and where it may also be, situation may be worse, where because of frustration, one party has incurred costs, and as a result is then demanding specific performance. So for instance, imagine the owner of that hall might have then spent some money to renovate the hall, to put it at a standard, in a condition that the wedding party, that the wedding, that the people that were celebrating, that wanted to celebrate the wedding, and expected it to be. And then, before that could happen, the bride or the groom or both of them pass away. So the situation like that, unless parties sit down and come to what you call a negotiated settlement, they may have to go to court. And if they go to court, then the court will decide whether the contract has been frustrated or not, such that one party is discharged from performing its obligation under the contract. Like I said, the other relief will be where the contract itself actually makes provision for what will happen where there is delayed performance or non-performance. In that situation, if frustration cannot be invoked, if force majeure cannot be invoked, then the provision of the contract as it deals with delayed performance will just be invoked. Now, let's talk about labor crisis or labor issues. I understand that some people have been signifying intention to ask questions. I would suggest that I think there is a Q&A feature. If you can kindly use that at the end of this session, of my session, we will take your questions, hopefully one by one, and then answer them. Labor issue is pretty straightforward. One is that most offices are closed, most businesses are not operating. The question arises whether employers should continue paying employees that are not working. Then this issue becomes more critical when you then realize that because the business is not operating, cash flow is scarce, cash flow is under significant pressure, and employers need to take decisive action on what to do to stay in business. Of course, a live issue that comes to mind is the Access Bank issue, where it is said that Access Bank donated 1 billion and now they are laying off so many employees. Of course, they've given their explanation, but part of the issues that they have raised as in the explanation is also opposite here. So for instance, if as a result of COVID, you now have to, in order to stay in business, you need to reduce the scope of your operations, you need to close down some branches, or you need to deploy technology instead of using people to run around in any way because of the lockdown. Then ultimately you need to deal with labor issues. Now, how do you deal with labor issues? There are various ways. Some people are contemplating salary and benefit reduction. Some are contemplating declaring redundancy. Some are considering just sacking staff. Redundancy and sacking staff are more or less the same thing anyway. It's just that process that is different. Now, if you decide to vary the employment terms of the staff, it must be subject to unequivocal consent of the employees. You must realize that employee master-servant relationship, employer-employee relationship is also a form of contractual relationship. The letter of employment that has been issued together with staff handbook constitutes a contract between the employer and the employee. And any deviation from the provisions of those documents must be with mutual consent. Of course, we know that in situations like this, you don't have what is called equal bargaining power. And as a result, most often than not, the employer will get away with whatever he or she proposes. But it's always better to cross your T's and dot your I's so that you do not open yourself to costly litigation. Imagine in the situation where you are trying to cut costs, you then incur additional expenses in avoidable litigation. And that has been the case. We all know that a lot of us can recall situations where even where staff had been fired or sacked or the employment terminated justly, they still go to hire a lawyer to write a letter and to make crazy demands. So how much more under circumstances where they can then maintain a just and justifiable claim against the company. So any variation to employment terms must be subject to unequivocal consent of the employees, meaning that they must sign in writing, they must consent in writing to the variation. If they're going to reduce salary, if they're going to defer salary, if they are going to defer payment of what's it called again, of allowances, anything that you want to do that will vary their entitlement, it must be they must be with their consent and must be in writing. And so negotiation, everything must be in writing and must be signed by both sides. Now, when it comes to termination, there's a little bit of confusion, but my position is that the situation is clear. In Nigeria, the law still remains that the employer may terminate the contract of an employee for no reason, any reason or no reason at all, provided that the termination procedure agreed in the employment contract is adhered to. When you sign an agreement, both of you, employer and employee, agreed that the relationship will be brought to an end in this manner. And as long as that manner is complied with, it is lawful termination. It becomes unlawful if that procedure is not complied with, or if a reason is given and that reason is wrong. So it's always important not to provide any reason because you have a right not to. But if you must provide a reason, then the reason must be cogent, germane, and true. I am aware that the National Industrial Court has been saying that that's based on the various International Labour Organization conventions that Nigeria is party to, an employer cannot terminate contracts for any reason or no reason at all. As a matter of fact, the court has held in several cases that you must give a reason and that your reason must be cogent and accurate. However, we know that Nigeria practices what we call judicial precedent. The highest court of the land is the Supreme Court, and the Supreme Court's position is that as far as the law is concerned, employer can terminate for no reason or any reason. Another issue is that the conventions that the National Industrial Court seeks to apply in Nigeria has not been ratified by the National Assembly. Our Constitution says that for any convention, international treaty, to be enforceable, to have legal effect in our country, it must be ratified and passed into our own law by the National Assembly. That hasn't been done, and because of that, we maintain that you can't terminate your employees for no reason or any reason at all. But my advice will be that if you do the redundancy has rules guiding it. One is that last in, first out. So what that then means that if you declare redundancy, you may not be able to terminate the contract of the least productive people in your business. So in a situation where the last in is the most productive, then you will not be able to retain such a person if you do a redundancy. Second is that in a redundancy, you also need to negotiate redundancy compensation for them, which may then expose you to higher obligations than what you will be entitled to do if you just do a simple termination of contract. Next issue is data protection. Now, data protection issue comes up almost immediately, particularly for those of us who are in service industry, and then we have to work from home. The issue that comes up, two issues come up. One is confidentiality of corporate information. And second one is if your company processes personal data. Personal data in this situation means information about human beings, information that you can use to identify human beings like name, phone number, email address, pictures. Now, if either your company processes such data processes such data, and then you need to work from home, or some of your employees need to work from home, issue of data protection comes up immediately because sensitive information is being processed in domestic setting. We are all aware of situations where people's application, people's exam scripts have been found to be used by suya people or akara sellers to wrap their products because someone took those documents and treated those documents in a flagrant manner. Same thing can happen too. The fact that the data is not in written form doesn't change the fact that it could be leaked carelessly, particularly where the information, the data is being processed in a domestic setting. Your sister can then see information about someone she used to know and then go and leak the information. Your uncle or your wife can then get information that is price sensitive and then go and use it to his benefit or something. All these things are potential risks that needs to be addressed. Now, for those who may not be aware, we now have a Nigeria data protection regulation, which seeks to fill the void that has been created by the absence or failure of our National Assembly to enact a data protection law. Essentially, what that regulation does is to give guidelines on how to deal with personal data. And where there is a breach, depending on the volume of data that you process, the penalty could be humongous, rising up to 2% of turnover, annual turnover. Now, lawful processing of personal data will be where you have obtained personal consent of the owner of the data, in this case, the data subject, or it could be from processing, processing or handling of personal data could be necessary for the performance of a contract to which data subject is a party. So for instance, online, people that are doing online merchandising will enter into sales contract with people online. In order to do that, they will provide their personal data. Processing also could be necessary for the performance of a contract to which data subject is a party, or take steps to protect at the request of the data subject prior to entering the contract. It sounds where, for instance, you apply for loan, and in order to process your loan, credit check needs to be done needs to be carried out on you. So there are different instances where use of personal data comes up. The law says that in order to, when you are processing personal data, then personal data must be secured from foreseeable hazards. Anyone who is entrusted with personal data or who is in possession of personal data owes a duty of care to the data subject. Data subject is the person, the owner of the data. Anyone who is entrusted with personal data too is accountable for his act and omission in respect of data processing. What this implies is that the company itself has an obligation towards ensuring the safety of personal data that is processing. And that obligation, that duty of care also flows down to the employee. And so steps need to be taken to ensure that the employees do not handle personal data carelessly. To do this, you need to have a data protection or confidentiality policy. As a matter of fact, the Nigerian Data Protection Regulation demands that you have a privacy policy. And that privacy policy must be consistent with international standard, and it will be published on your website. So you need to have that. You need to have a data protection confidentiality policy. You need to have, if where you are dealing with sensitive information, then employees must be made to execute data, what's it called, non-disclosure agreements. They must be trained in various steps, measures, cybersecurity measures that the company has adopted, embraced to ensure integrity of data. Such as, so all this needs to be taken into consideration to ensure that you do not become liable for data breach or privacy claim. And like I said, in recent times, one of the costliest claims that any business can suffer is data breach. Final issue is governance. I cannot overemphasize this, particularly for the small and medium enterprise, medium-sized companies. For companies generally, particularly in time of crisis, in time of what do we have now? Recession. It's important that the board meets regularly to give guidance to management. It is key. We have a code of corporate governance. The NCCG 2018, number one principle number one of our code of corporate governance says a successful company is headed by an effective board, which is responsible for providing entrepreneurial and strategic leadership, as well as promoting ethical culture and responsible corporate citizenship. Note that a successful company is headed by an effective board that is responsible for providing two things: entrepreneurial and strategic leadership. It says, as a link between the stakeholders and the company, the board is to exercise oversight and control to ensure that management acts in the best interest of shareholders and other stakeholders while sustaining the prosperity of the company. That is the job of the board. The job is to, so the company has been established as a legal fiction. The company sits between, the board of directors sits between the shareholders and the managers of the business. So what has happened is that the shareholders have contributed money and put the money at the disposal of the managers to manage the money and to run the business. The board acts as the agent of the shareholders to supervise the managers to ensure that they carry out the instructions of the shareholders and that they use and manage the funds made available in line with the aspirations of the shareholders, so that the interest of both the shareholders, stakeholders, and everybody is preserved. And so because of this, it's important that the board is able to exercise a supervisory role, particularly at a time like this. The Code of Corporate Governance says meetings are the principal vehicle for conducting the business of the board and successfully fulfilling the strategic objective of the company. In order to effectively perform its oversight function and monitor management's performance, the board should meet at least once every quarter. And so the lockdown should not be an excuse for the board to carry out its supervisory role. As a matter of fact, at a time like this is when management needs the combined experience of the board to guide them in identifying the risks to the business, putting together a risk matrix to handle the business, to handle the risks, and then to to ensure that the company continues on a trajectory that ensures not only its survival, but its prosperity. So, like I said, board must meet. The interesting thing in Nigeria is that because our law, the Company and Allied Matters Act, that's the law that regulates company operation, was enacted in the 90s, 1990 to be precise. It did not take into consideration the possibility, I guess the possibility of a virtual meeting wasn't as real then as it is today. And so meeting is discussed in terms of a physical meeting. For the past 5 years, where the technology for virtual meeting has become increasingly popular, what has happened is that most companies have altered the article of association to enable them meet virtually. And so where your articles permit you to meet virtually, then by all means, convene a virtual meeting, circulate necessary documents for the directors to read ahead of time so that they can carry out their function. Where the articles do not expressly permit virtual meeting, two things can happen. For companies that are small, if the directors unanimously agree, then you can have your board meeting virtually. If the board is big or the board cannot unanimously agree, then you may then need to alter your articles in order to meet virtually. But a situation where your article does not provide for virtual meeting and the directors do not object, go ahead, convene the meeting, comply with all the requirements for notice. And at the end of the meeting, you have two options. You can do what's called written resolution or secularized resolution, where everybody will sign and they will ratify any decision taken at that meeting. Alternatively, just to wait for the next subsequent meeting that's going to be a physical meeting, and then pass resolutions ratifying and approving all the decisions taken at the virtual meeting. AGMs could be done in the same way. Two things. So some people may decide not. The most important ones are is the board meeting, which should be done quarterly. AGM is supposed to be done once in a year. It's supposed to be done within 15 months of each other, and you can get you can defer it for another 3 months with the permission of the CAC. Where it is very important for you to have an AGM, for instance, where there are certain shareholder resolutions that need to be passed, or where AGM is time sensitive and needs to be held. You can hold a virtual AGM. Holding your virtual AGM, you must comply with all the other requirements for the AGM. Note that the venue for an AGM must be in Nigeria. So that means that your notice must indicate that the AGM is going to be held in Nigeria and that participation may be virtual. And then the quorum too must be complied with. And so once you're able to do all this, you've covered the key concerns that may arise from a legal perspective as a result of COVID. Thank you very much. Any questions? I guess Akinwumi will deal with the protocol for asking questions.
Yes, sir. So thank you very much, Mr. Oshundolure. I felt like I was in a legal class, and I think I'm almost becoming a lawyer already. Thank you for that session. It was good. And one major thing for me was it actually helped to identify basic issues, major issues that is possible to encounter as a result of this crisis. So once again, say thank you for that. So we'd like to take questions at this point. So please, if you're there and then you have questions, please feel free to use the question and answer section, to post your questions, and Mr. Oshundolure will take your questions. So the first question that we have says that what happens when a new employee was supposed to resume at the beginning of the lockdown? That means on the 1st of April. However, the business has been put on hold since then. Is the employee entitled to a salary?
So note that no, to a large extent, you don't have a yes and no answer. It all depends on the facts of the case. So on the fact of this case, if it was supposed to resume on 1st of April and the lockdown was affected and it couldn't resume, then it's not entitled to salary. But remember that there are different issues may come up. It may then be that while he's not physically resumed, you've been sending working from home, and he's been carrying out, so he has not physically resumed, but you have onboarded him. He has an email address, he has everything. He has identification documents provided to him, and in addition, he's offered certain services or performed certain tasks. In a situation like that, it will be difficult to say that he hasn't resumed. So the fact of each case will have to determine whether indeed he has resumed or not. So then say that he justifies payment of salary. But it's always better to have contacted. The best thing would have been that on that 1st of April, you could have contacted the new employee and have given out necessary directives so that both sides are clear of what is expected of each other. Thank you.
Okay, thank you very much, sir. Tokumbo Oworu, please, can you just use the question and answer um, section to ask the questions? Just for coordination's sake, we won't allow voice. We'll take questions via voice. So another question says that um, for a staff that was not engaged with a contract letter, nothing was put in writing. So is it required that the person must also be disengaged with with writing? So when you brought the person on board, there was no contract letter, it was just verbal. So now you need to disengage the person. Do you now have to put it in writing?
Well, so you need to understand that in contract, you have express contracts and you then have implied contracts. The law can look at the relationship between the two of you and imply contracts and imply the terms of the contract and then impose obligations on both parties. So the fact that there's nothing in writing does not mean that the person hasn't been engaged. And in termination, it would be advisable. So there are two sides to it, really. For record purposes, you should put something in writing because you then don't want the person then continue. There's something that is called ostensible authority, where if I have passed this person across to you as someone that has authority to bind me, whether or not there's express authority, the person can continue to bind me until you give expressly give an indication to negative that impression. Other than that, it would be nice if you can terminate the person without any written document. That way, there's nothing to hold against you. But like I said, you also need to be sure that all your tracks are covered in taking such decision.
Okay. So the previous question about an employee who was supposed to resume. So the person sent an additional information to say that he has not been onboarded at all. So there was no resumption.
Yeah. So there's no resumption.
Yes.
But like I said, you need to look at the surrounding facts. Based on the facts that I have right now, I will say no, there's no resumption.
Okay. So I think another question would be that, so in the case where, and I think you got touched on a bit on that during the presentation, in the case where you have a contract that says you're supposed to deliver this project by this time, and because of all of this, that time has elapsed. What are the exact steps that you need to take to go forward on that contract?
Can you please repeat again?
I said that in the event where you have a contract, whether to complete a project by, let's say, the end of April, because of all these that have happened, that date has elapsed. What are the exact steps that you need to take to move forward on as regarding that contract?
Number one is to look at your contract and to see what the contract says. What the contract says if something like this happens, and then from there you will know what to do. If it's silent, then you need to then initiate contact with the counterparty to confirm what you can do. If the contract is not silent, then you then invoke what the provision of the contract that is relevant to your situation. And in doing that, remember what I said about force majeure. Issue of force majeure can then come up. But like I said, force majeure is dependent on how it is defined in your contract, whether whether this situation is included in what has been described as force majeure in your contract. Note that if it is not, you can still raise the issue and negotiate that negotiate that it should be included. And if the other counterparty is reasonable enough, they may agree to amend the provisions of the force majeure to include a situation like this, and you can then initiate the provision of force majeure. But also note that you need to comply strictly with the provisions of the force majeure clause. So force majeure clause would usually say that, look, once your performance is affected by a force majeure, notify me, notify the other party. As a matter of fact, what you find is that some other contracts will actually give you the timeline within which you must notify, within 3 days, within 5 days. And if you fall out of that, it becomes difficult for you to rely on the provisions of that clause because you have not complied.
Okay. All right. Thank you very much for that. So there's an addition to one of the previous questions again that said that, so the person that was supposed to resume on the 1st of April, he actually resigned from a former work to pick up this new job. But he never resumed this job. Any additional insight?
But there is none really. Those are the issues of life, and it's difficult really. I will imagine that if I were so issue number one will be that one of the things that we have not about our mind to is that does he have a a contract of employment?
Okay.
What does the contract of employment say? Usually you have a situation where before the person would have left, he will have signed a contract of employment, says that your employment starts on X day. And if that's the situation, then whether he has resumed or not, he has a contract of employment that says that he's your employee.
Yeah.
Exactly. And so the issue will be, and so the argument will be that there always the argument that whether the employer has to work or not, the employee needs to present himself for work. And so the obligation of the employee is to make himself available for work. The obligation of the employer is to pay him for services rendered. So the question would then be that, has he presented himself for work? If he has not presented himself, then supervening issues will come up. So as in this case, of course, usually you don't put force majeure clauses in contract of employment, but it's convoluted because I can argue that, look, I have a contract of employment with you, and that contract of employment says I'm entitled to X at the end of each year, end of each month.
Yeah.
You are entitled to pay me. And the fact that I couldn't be physically available does not mean I'm not available, particularly if I then call you to then say, most likely what I expect that a conscientious worker will probably do is to then call you on the day you're supposed to resume, that I'm supposed to resume on this day. What should I do? So, like I said, the law is not cut and dry. It's always.
Okay, thank you, sir. So this next question says that an individual was given an offer letter, but he was never called to resume. All attempts to get a reason for the non-resumption was frustrated. What do you advise him to do?
So there are two stages. Did he sign the acceptance? Usually when you're given an offer letter, you're supposed to sign an acceptance memorandum and submit, indicating that a contract has been concluded. And then performance is resumption. And failure to resume could then result in treating the contract as having been rescinded, and then you can go ahead and you owe no obligation to that person. That is one case. Another case is where the person did not even submit the acceptance memorandum in the first place, because usually the offer letter will come in duplicate.
Yes.
And you'll be required to sign the duplicate and return. So even if you haven't done that at all, then that means there's no contract in the first place. And then the employer is under no obligation whatsoever.
Okay, thank you. So the next question says that, what advice do you give a client who refuses to pay staff salary in April because they were told not to work and the staff are now requesting for salary? Hello, sir, did you get that?
Yeah. It's a difficult one. He has an obligation to the staff which he should comply with. Otherwise, he might be exposed to litigation. It's better for him to manage the situation by entering into negotiations with them. Yeah, they do not work, but they're entitled. But you have an obligation to them under that contract, which they can then go to court to enforce. So I have a situation where the employee called.
Sir? Hello? Hello, sir, are you there? Hello? Okay, just give us a few seconds to just confirm Mr. Oshodobire's network. Just please hold on, please. Thank you very much. Okay, you're welcome back, sir. Hello, sir. Can you hear me?
Okay.
The next question says that, is it possible for a company to absolve themselves of an employee's fault in the breach of personal data, like a vicarious liability, or it must be added in the data protection and confidentiality policy?
No. What they can do is to get some form of, is to maybe, one, institute disciplinary action against the staff, and two, where necessary, get some form of indemnity from the staff. But they cannot waive, what you call liability, because in the first place, the responsibility, the party to whom the data was given is not the staff, is the employee. It's not the staff, it's the company.
Yeah.
The employee is just dealing with the, dealing with the data on behalf of the company or as an agent of the company.
Of the company, okay.
So the company still continues to be liable for the data breach. What can happen is that it then gives them ground for taking disciplinary action against the
employee.
Staff. Yes.
Okay. All right. So you say that concerning force majeure, can a contract that started before the COVID-19 lockdown and is still on apply the provisions of force majeure? So the contract
It
started,
can.
it can.
Of course, it can. It can. Remember that. So usually, what will happen is the standard force majeure clause will say that if the performer, it will say that look, that failure of performance under this contract for any reason attributable to a force majeure will not constitute a breach, entitling, it will not constitute a breach. They would then say that in event of a force majeure, you should do X, Y, Z. That's usually the way it is. It does not matter. It does not matter when the contract was executed. What matters is that the contract is still effective. It has not been terminated, and the event that has occurred during the life of the contract. So assuming that I have a contract, I have a 1 year contract to provide deliveries to ShopRite, and 4 months into it, COVID occurs, and I cannot deliver. That does not mean that the fact that it was executed in December does not mean I can. As a matter of fact, this is the time when I can do it. It's supposed to manage our risk during the life of the contract.
Okay, I think we have about 2 more questions. So it says that owing to the incidence of complete business shutdown, after the company had series of meetings to explore how businesses could manage to have some work to do, a staff was paid the March salary and written to observe a temporary no work, no pay while the company observes how soon it can return to business. The employee expressed disappointment by resigning and was reluctant to hand over the company tools and information. What would you advise?
That's conversion. If you have resigned, then you should hand over company's property. Otherwise, it amounts to conversion, and it could be criminal or it could be civil. Because the moment you stop being a staff, you are not entitled to hold the company's property. You should return the company's property, particularly where the company does not owe you any money.
Okay, so what can the company do?
The company should write in to demand the return of their equipment. If he fails to do that, then there are 2 options. They can institute an action in court, or they could report a case of criminal conversion to the police.
Okay. So one last question. An employee is asking that how can an employee enforce a force majeure?
Like I said, so number 1, in order to invoke a force majeure, your contract must contain a force majeure clause. If your contract does not contain a force majeure clause, you cannot invoke a force majeure obligation or provision. That is 1. And 2 is that you hardly find force majeure provisions in a contract of employment. You hardly find it. If it is there, then the contract itself will tell you what to do to invoke that provision. Hello?
Yes, we're with you.
All right. So those are what I would say. You hardly find a force majeure provision in a contract of employment. But if it is there, a properly worded force majeure provision will also contain guidelines, procedure for invoking the provision of, for invoking its provision. And so you just comply with that provision. That's all.
Okay. Okay. All right. I think that's all the questions that we have, except for a few comments. Somebody had mentioned if B&I attends to SMEs at a friendly and affordable price. Okay, and yeah, I think those are the major questions.
Yeah. So how
Okay, go
will I
ahead.
say? Yes, we do. We also have areas of interest. And if
Okay.
your business falls within those areas of interest, then we are particularly encouraged to work with you. So, for instance, over and above everything, we are interested in the technologies area, particularly
Yes.
fintech. Fintech, regtech, medtech, technology, really, as well as media and entertainment.
Okay.
But that does not mean that we will not work with SMEs, particularly SMEs that we feel has the potential for growth. But the issue is we also have our area of interest for now that we want to support.
Okay. All right. All right. Thank you. One more person wants to know if they can have access to the slides, to the presentation.
Okay, no problem.
Okay. Okay.
I'll share it with you.
All right. All right. Thank you very much. So, on behalf of the Executive Director of the Foundation, Adenike Adeyemi, I want to say thank you very much to Mr. Oshindoliro. Thank you for obliging us to share from your knowledge and for taking out time to prepare for this presentation and be with us for the last 1 hour, 30 minutes. Thank you very much. And of course, to everyone who joined the session, we hope that you had hope you got something valuable out of it. And this is just one of Faith Foundation's efforts to support entrepreneurs across, of course, the Nigerian space in this period. We would come up with a couple of other sessions as we go by, and we intend to share that with as many people as possible. And I'm sure that you will find it useful also. So once again, I say thank you very much to everyone for joining the session. Do have a wonderful evening and a wonderful week. Please, let's still stay safe. Let's stay safe. The virus is still out there, even though the lockdown is over. But let's still stay safe. If we don't have to go out, let's still stay indoors and work from home. So once again, on behalf of everyone at Faith Foundation, we say thank you very much and have a good evening. Bye for now.